So let's make a start. Hello, everybody. Good morning and welcome to day 3 of Birmingham Tech Week 2020 and today's session on clearing the 5G patent forest. Before we begin, we just have to share a few words from the Tech Week sponsors and partners. Next slide. So Birmingham Tech Week is brought to you in association with TechNation, the West Midlands Growth Company and the Department for International Trade. Next slide. And the 6 sponsors. Next slide. And a whole lot of partners. Next slide. And of course, Marks & Clark, who are hosting today's webinar. Next slide, please. Could we just back up a slide, please? So if you can't hear me, then you won't be able to hear what I'm saying now, but you will at least be able to see that any sound problems could be due to the GoToWebinar panel picking the wrong output device by default. So if you do have this problem, just check your audio settings and change to the correct audio source. Next slide. And if you can't see the GoToWebinar panel, then it may be hiding in the system tray, which is in the bottom right of your screen on a Windows PC. It could be hiding on your second screen or behind some other windows, or it could just be minimized, in which case just click the orange arrow. So from that you can adjust your audio device and also ask us questions. Next slide. So today's webinar is going to be an interactive one. You're welcome to ask questions to the panel, and what we're planning to do is to answer your questions at the end. So if you open up the GoToWebinar panel and enter your questions in the questions box, we will do our best to answer them. Next slide. So today's webinar is on clearing the 5G patent forest. Your panelists today are me, Philip Cupid from Marks & Clark, Josue Ortiz Ramirez from Deloitte, and Simon Portman from Marks & Clark Law. So I would just like to ask the panelists to briefly introduce themselves. Josue, could you start, please?
Yes, thank you, Philip. Hello, everyone. Thank you for joining. Yes, my name is Josue Ortiz Ramirez. I'm a director with Deloitte, and in particular, the IP advisory practice based out of the UK. I've been in telecommunications and intellectual property for about 20 years, primarily around areas of IP-related transactions, such as licensing, patent acquisitions, disposals, and IP valuation. It's a pleasure to be with you today.
And Simon?
Hello, I'm Simon Portman. I'm a commercial lawyer based in Cambridge, but I'm in Birmingham quite a lot, or was before we all got locked down. I head our virtual reality team, and I give tech companies advice on commercial contract issues, such as securing ownership of their IP, licensing, R&D, distribution and manufacture. And so we're going to be covering some of those issues today, and it's great to be here.
And finally, I'm Philip Cupid. I'm a partner at Marks & Clark based in Birmingham. I'm a patent attorney, and that basically entails helping companies to protect their own inventions through the patent system, and also helping companies to deal with their competitors' patent rights. And as part of this, I do quite a lot of work in the telecom sector, both for companies who are trying to patent parts of the telecom standards, but also other companies who want to know how they can use the 5G standards in their products. So our first, in order to understand about the 5G patent forest, it's helpful just to understand a bit of the terminology. And so first of all, what are standard essential patents? How can it be that something that's an industry standard as 5G is, can be encumbered by patents. Next slide. Well, first of all, let's briefly refresh ourselves on what is a patent. Well, a patent is a legal right to stop other people using a particular invention. It's important to realize that having a patent doesn't mean that you're allowed to practice the invention yourself. It's perfectly possible and indeed very common that you can have a patent on a bit of technology, but you're not free to actually use it because someone else, one of your competitors, has a patent on a more fundamental bit of technology. Patents are granted by patent offices. That's basically what a lot of my job is trying to get patents accepted by the patent office. And then if there's ever a dispute about the patent, that is dealt with by the courts. A patent lasts for up to 20 years. Now, this is quite interesting because the duration or term of a patent is much longer than the standardization or the life of a particular standard. So currently we are still seeing some of the patents on 3G technology. They're still there and in force. Similarly, as people are now working to patent 5G and 6G technologies, these patents are likely still to be in existence when everyone's talking about 7G or 8G. Next slide. It's also, in order to understand how patents and standards interact with each other, it's also necessary to understand how standards are made. So for 5G, standards are made under the umbrella of an organization known as 3GPP, or the Third Generation Partnership Project. Its name derives because this was one of a couple of rival groups that were trying to set the standards for 3G back in the noughties. Now, under the umbrella of the 3GPP, a number of different competing companies all get together to try to agree on how a particular technology should work. So these companies involve, as you might expect, the handset manufacturers, also the makers of network infrastructure, but also a number of companies who perhaps are a bit surprising. So companies like Airbus, general software companies, lots of companies are all involved in the standardization process. As of today, I think there were 753 companies who were registered as members of the Third Generation Partnership Project. Now, the thing that brings all of these companies into the same room and gets them to agree on a particular technology is the existence of patents. What happens is that these companies invent something that they think will be a useful advance to the technology and will improve upon the standard as it currently stands. They apply for a patent, and then they go and suggest their technology to the other members of the group. If they're lucky, the other members of the group will say, hey, this is a great idea, let's incorporate it into the standard. And the payoff for the company's hard work in R&D is that they can then charge a royalty to other people who wish to use the standard. So just to summarize then, the companies invent the technology, it gets incorporated into the standard, and the payoff is that they can then charge people to use the standard, or at least they're part of the standard. Next slide. So this leads to the concept of a standard essential patent, or sometimes referred to as an SEP or a SEP. The existence of these patents means that the technologies are not free to use. A patent is said to be essential if you can't implement the standard on technical grounds without infringing the patent. So in other words, it's impossible to create something that works in the way that's envisaged by the standards without either taking a license or infringing the patent and risk being sued. So It's thought that there are around 10,000 families of standard essential patents. That is just a huge number. Indeed, the number of 10,000 is probably quite a conservative estimate. I've seen other numbers of 13,000 or 16,000. It all depends on how you count it. No one really knows for sure how many there are. And indeed, the standard setting organizations, they are not responsible for judging whether something is essential or not. It's the onus is on the companies who invent the technology to declare their particular patents as being essential to the standard, and if there's ever any dispute, then it all gets sorted out in court. Next slide, please. So you might think, well, I'm not in the telecoms industry as such. I make smart products or I make software. Why should I care about this? Well, it used to be the case back in the days of the smartphone wars that all the litigation in this area, all the patent litigation was between rival smartphone manufacturers. We saw companies like Apple and Samsung quite famously fighting it out in court. But what we've seen is that most of the disputes between the telecoms companies have now resolved. And the owners of these standard essential patents are looking to find a broader revenue base. And what they're doing is they're looking to extract licensing revenue from companies who implement 5G technology in their smart products. So just as an example, from this silly little drawing at the bottom of the screen, what we've seen in Germany is Nokia fighting it out in court against Daimler, who are the parent company of Mercedes-Benz. And this is all about a question essentially of who pays for the taking a license on Nokia's patents that cover parts of the 4G standard. So let's say you just choose not to engage with it, then the whole patent process and understanding the patent landscape, this could be quite dangerous for you as a business. You risk being injuncted by the courts, which would tell you to stop doing what you're doing right now. You could face an award of damages, which could be very costly indeed, and also you'll incur legal costs. So it's much better to try to understand how patents cover the standards now and to decide your strategy before you end up in a costly legal dispute. And next slide, please. And now over to Josue, who's going to tell us about the business and commercial aspects of standard essential patents.
Thank you, Philip. So Jesse, we could go to the next slide, please. So let me begin by telling you a little bit of a bit more about where I'm coming from into this presentation and what we do at IP Advisory, particularly related to ACP's 5G and a collaboration we have with the West Midlands Authority to create a 5G accelerator. So basically, we are involved in all aspects of the IP lifecycle from a commercial and strategic perspective. And what you see highlighted in green are particular examples of activities or projects we've undertaken around ACPs and 5G. So for example, in recent times, we have been involved in actually acquiring 5G related patents for a particular company in Europe. In previous years, we did substantial analysis of a telco's portfolio to help them understand which of the patents were actually standard essential. So back to Philip's point that this particular telco had been involved in standardization activities. They had made technical submissions and filed patents, but obviously through the course of prosecuting those patents and the standards evolving, sometimes there is a bit of a misalignment between the standard and the patent, and so they needed to understand which patents they should actually declare and which ones were truly essential. And similarly, moving down to sort of the defense aspect of our activities, so we have been actually on both sides of licensing negotiations, both helping handset manufacturers engage with SEP licensors to try to secure a good commercial outcome. And in previous years, we actually supported in earlier cellular technology, actually licensing out into the European market. And we've done quite a bit of analysis around risk and royalties and financial outcomes in support of such negotiations. In terms of the 5G accelerator called Spring, so the IP advisory team will be providing ad hoc support services for those companies that come to the accelerator in terms of trying to help them understand whether they might have an invention that might be patentable, and that's where people like Philip would get involved as well. Also helping them understand the IP strategy and the processes to secure a suitable IP protection, and just generally helping them make sure all of the whatever it's created is properly protected, whether it's through patents or other IP means. Next slide, please. So just to begin by giving you a little bit of an update on 5G adoption outlook, and this is important because the issue around SEPs and licensing and royalty rates, it doesn't actually exist in a vacuum. It exists in a certain context, and it's important to understand that commercial context. So the first thing to say, clearly the top 3 charts that you see on the screen are actually from a GSMA report, which is the GSMA is an association of mobile operators. This was published last year, and basically what you see on the top left is, as has been in the press, a massive adoption of 5G, around 1.35 billion connections expected by 2025, and roughly 40% of coverage from a geographic perspective. That's a faster acceleration than in previous technologies such as LTE, and that's partly because of adoption in China becoming quicker, probably some lower cost devices, or certainly lower cost devices outside of the handset space. So a whole range of reasons why this is expected to be a fairly quick take-up. And that has the consequence of having a huge impact from an economic perspective in terms of value add. So there is an expectation that $2.2 trillion will be added to the economy by 2034 as a result of 5G. Most of that value add, so that's roughly twice what it was for the mobile ecosystem in 2018. And most of the reason for that additional value add is actually efficiencies. So, and you can see the split there in terms of how that 2.2 trillion is distributed across various industries. Now that obviously has huge geopolitical and economic implications that you have seen in the press with trade wars and so on, with obviously governments very keen for technology to be adopted, new applications to be developed, a variety of use cases supported by 5G to actually to exist. And so, significant opportunity for innovation, new products, new services, which is a bit of a virtuous cycle in terms of accelerating adoption. The other thing to note is, obviously with 5G, there is an expectation of, let's say, radical new services and offerings. So the chart on the top right, what that's showing you, it's basically that there is a range of mechanisms by which we will interact with 5G. So there will be, as it is today, person-to-person communication, person-to-machine, and machine-to-machine. But also there are some core services that exist now which will evolve. Probably penetration will increase. And then there's what is called extended opportunities and new horizons. And this is what often captures the imagination of the press in particular. So things like robotic surgery conducted at a distance, very advanced smart metering applications, and so on. So huge opportunity for innovation, and all of that then will fuel increasing number of devices connected, and therefore potentially additional patent-related issues, as we'll see in a minute. The bottom slides are actually a study that Deloitte published in June. And this is a survey of around 450 executives in a variety of industries. And this basically was intended to try to understand what the perception is within different organizations about 5G adoption. And what you can see on the bottom left chart is that within 3 years, basically there is an expectation that 5G will be more important than 4G for most organizations. The next chart on middle of bottom is that again, within 3 years, there is an expectation that organizations and industries will be transformed by 5G, so they will look fundamentally different. Now, obviously, because of the variety of use cases and devices, if you are an innovator developing a new product or solution, you need to think for the various industries, what are the most likely early adoptions. And so, for example, on the bottom right part of the slide, particularly for machine to machine, if you look at the top use cases by industry, they actually vary between TMT, consumer, and energy. For some, analytics is more important. For others, predictive maintenance is more important. So this means that adoption and licensing will vary by industry and by use case. Next slide, please. So what about the patents then? What about the previous slide is obviously very optimistic, a lot of opportunity for products and innovations and financial rewards as well. But yet when we hear, so the top, the left-hand side of the slide shows a recent article on the Financial Times, end of July, and this was about a deal that Qualcomm completed with Huawei. And there are obviously huge numbers mentioned, 1 billion basically to resolve that particular dispute. And if you think about it, that's one company, and that's actually in 1 quarter that 1 billion figure relates to. Interestingly, this seems to be a combination of legacy issues plus there is a link to 5G in there. It is also a bit of catch up on royalties that had not been paid, and then future payments as well. But very significant numbers and clearly fully related to patent related issues. On the right hand side is an article also quite recent, actually from this month in Bloomberg, which highlights a number of things. Again, a huge market growth projection and a little bit doom scenario, which the commentator is saying, well, actually, we could expect this is 10 times worse than the smartphone's patent was, partly because this diversity of use cases and devices, but also new industries such as automotive implementing the technology, but also a variety of companies and organizations with different historical attitudes to IP and frameworks for licensing. So all of those things can create quite a bit of tension between the participants. And also on the right-hand side of that article, it sort of highlights some of the recent court cases, and particularly the ones that have been, let's say, beneficial to the patent holders in terms of supporting of the licensing activities. So yeah, clearly a potential issue in the horizon. Let's have a look at the next slide to sort of try to understand the scope of the problem. And Philip already mentioned the volume of SEPs. So what this slide is showing is basically some findings from 2 separate studies. On the left-hand side, on the top right, is a study by a company called IPlytics in Germany and the Ministry of Economic Affairs in Germany as well. They basically looked at the volume of patent families that have been declared to 5G standards, and you can see that in green is the number of families. So a family is basically an invention, or can be multiple patents that relate to the same invention. And then in blue are families that have at least one granted case. So obviously, again, very significant numbers in excess of thousands for certain players. The bottom right is from Ericsson. The data is from Ericsson quoting a bird and bird analysis. which basically applied an essentiality filter. So the numbers on the left-hand side are, as Philip said, simply what patents chose to declare, what patent holders chose to declare as essential patents. The bottom right is actually applying a filter to that. So what are they actually essential? So slightly different numbers, but I think the key issue here is no matter how you look at it, there are a lot of patents, and there are, in whatever your top list of 15 is, there will be many active licensors on either list. And also the top right, what that is saying is if you look at the declared families by 3GPP subgroups, or by areas of the standard, it actually covers all of them, with some concentration around the radio interface in particular. So let's go to the next slide, please. So what are the cost implications then? What can we expect? And to sort of begin thinking about how we might respond to this, or how you might respond to this. So few things to highlight here. So the data on the slide is basically showing expectations for licensing into the smartphone space in 5G. Some data unconfirmed, but basically that Ericsson and Nokia are hoping to charge a fixed fee per handset between $5 and $350 per device respectively, with Qualcomm actually charging a percentage. On the top right is actually a disclosure from Qualcomm. It's available on the website. And they basically talk about royalties rate between 2.275% and 3.25%, depending on whether a device is single mode, so only 5G, or multi-mode. And then the bottom right shows similar disclosure from InterDigital, where they have a 0.6% per device, but that's actually with a floor and a cap. But it gets more complicated. So interestingly, here are 3 licensors, all with different, not only different numbers, but different approaches to licensing. And it gets more complex than that, because both Qualcomm and InterDigital mention other patents. So Qualcomm mentioned in particular that they also offer a license, let's call it a bundle, that includes ACPs, but also what is sometimes called implementation patents. So these are not standard essential patents, but rather they are patents that cover aspects of 5G that implements may still want to use. And that then carries a license of 4 or 5%, depending on whether the device is single mode or multi-mode. And then InterDigital also mentions other technologies, such as high efficiency video coding and Wi-Fi. So you have to bear in mind that a device will have multiple standardized technologies, not just 5G. And so what we have is a variety of licensors, variety of technologies, variety of patents, SEPs and implementation patents. And this is only for the smartphone. So there is some indications around $15 per car for earlier technologies. Some people say in aggregate it's probably $30, but no public information as of yet in terms of 5G royalty rates for automotive, and no visibility really about any other use cases. And as you can imagine, when you look at the variety of applications that 5G enables, the net result is that there has to be price differentiation. You cannot have the same numbers for a car or a handset or a sensor. And that is going to be quite challenging. There is this statement there on the bottom left that estimates a total royalty burden for a handset of around 7%. That seems a little bit low to me in terms of when we compare to earlier technologies, but let's say 7 to 10% perhaps in a handset. Is that actually achievable in an inexpensive sense? So that's where part of the dilemma is in how this is going to be licensed. But in any case, the numbers are significant. The motivation for licensors to pursue licensees is actually very, very strong, and it will happen, no doubt, and it's already happening. So next slide, please. So what could somebody then do in response to this? This slide is largely written from the perspective of, let's say, somebody who is innovating, creating a product and is approached by a licensor. But actually, some of the principles suggested here also apply if you're a patent holder and you want to license your IP. What we have seen in terms of client response is that, broadly speaking, at a very high level, there are two approaches. One is very reactive, and the other one is proactive. The reactive approach is basically saying, well, let's not do anything until somebody comes knocking. And there are good reasons for that. We understand it. So, for example, a reason might be legal caution. So, why go looking for problems if you don't have one yet? And what might any information that is detrimental and you find, what could that do to you if it ever goes to court? So that's a valid concern. Another one, which is very common, is an unwillingness to fund any proactive activities, because why invest money in some sort of proactive defense approach or proactive licensing approach when you don't know that it's going to materialize? So those are common issues. But what we have yet to find a client that has actually supported a proactive approach, which wasn't a good investment. So it's just a very simplistic slide on the left-hand side, perhaps. But somebody could invest in some sort of risk assessment and mitigation exercise, and depending on what that involves, it may be up to, let's say, $1 million, maybe even a little bit more. That is perhaps more expensive than if you decide to try to invalidate a US patent. So that's what an IPR refers to, is basically an invalidation process in the US, which tends to cost around $250,000. If you assume 3 of them, then you're suddenly already above what a risk mitigation approach might involve. And then if you end up in litigation, then you're looking at $3 to $4 million in the US, at least, per case. And then if you end up settling a case, then it easily $10 to $50 million. And then obviously that doesn't take into account any if it's royalties that may have to be paid. So the reactive approach very quickly gets very expensive, and you lose control of the situation. In response to that, and on the right-hand side is an example of some modeling that we did, which was basically trying to model the cost of responding to an incoming licensing approach. And this is not specific for 5G, it's very agnostic from an industry or technology perspective. But basically, it is possible to quantify the cost of any response. There are a variety of scenarios of how a licensing approach may develop and what the outcome might be. But basically, we model the expected net present value of different outcomes, depending on whether you are proactively responding or you have a moderate response. And when you look at the range of possible outcomes, in general, it's quite an expensive proposition to be purely reactive. So what we would say in terms of when we put all of this together, how to respond to the 5G patent forest, there are a number of takeaways there that I'll obviously let you read, and the presentation will be available. But by and large, what we would say is preparation, regardless of whether you are an innovator who may be approached with a request to take a license, or whether you are a potential licensor. Developing strong negotiation arguments, understanding the economics, how you fit into the various portions of the standards and the use case that you're implementing. All of those things are important so that you can actually respond. And I think it's important to understand that at the end of the day, it is a negotiation. Even if it ends up in court, there is a point of commonality between the licensor and the licensee, which is actually wanting to drive adoption. Because royalties are paid if the product is successful and it grows in the market. And equally, if you are a product or service company, that's what you want to do as well, is for your product to be successful. And there is an argument that despite the smartphone patent was, that didn't actually stop the industry. So the smartphone is clearly one of the most successful products of all time in terms of growth and market penetration. It certainly would have had an impact on price paid by the consumer in the end, but that doesn't seem to have stopped all of us from owning smartphone devices. So I think that's important to look at these negotiations with objectivity and trying to reach a commercial resolution. So I'll hand over to Philip now. Thank you.
Thanks, Josue. So as Josue has said, it's good to take a proactive approach to try to seek out the patent owners and try to enter negotiations early. That in terms of your overall cost of getting licenses to the patent or various patents, that ends up with the most favorable net present value to you. So let's talk a little bit about how we go about that. So I said before that a patent is a right to stop people doing things. Isn't it possible that the owners of all these patents could be really mean to you and decide they're just going to exclude you from the marketplace by not allowing you access to their patents? Well, no. As one of the requirements to participate in the standard setting process, all companies who join as members of the standardizations organizations, they have to make an undertaking that they will grant licenses, that is permission to use their patent, on what are called fair, reasonable and non-discriminatory terms. Now, the meaning of that is something for the courts. It's something that is open to a lot of discussion, but generally speaking, what fair and reasonable means is that there needs to be a balance between the rights or the right of the patent owner to be rewarded for their innovation, and that has to be balanced against the benefits of the public of having access to a particular standardized technology. And non-discriminatory means that similarly situated licensees should pay a similar royalty rate. What this doesn't mean is that the patent owners are obliged to give you a license at a bargain basement price. It doesn't mean that all licensees pay the same amount for a patent. Very often, perhaps the people who sign up to license a patent first, they get the best rates. The people who come to the party later get much less favorable rates for to use the right to implement the patented technology in their products. What's also important to note is that the royalty rates are not set by the standard setting organizations. The standard setting organizations are there purely to handle the technical aspects of the cooperation. They want nothing to do with setting license rates. So the actual license rate that you'll pay is basically up to you. It's down to how you negotiate with the patent owner. Next slide, please. As we've seen, there are an awful lot of patents out there and an awful lot of patent owners. Although a lot of the patents are focused in 10 or so big companies, there are a whole lot, maybe approaching 100, depending on how you count it, people who have a patent covering some part of the 5G standards. Now, this is an enormous challenge for any company seeking to implement a proactive approach. It's going to take a lot of bandwidth, not to mention money, for you to go and negotiate with all of these companies and strike a bargain. So this is, it is definitely a problem. Another difficulty is what's called royalty stacking. So if you have to pay 2.5% of your sales price to one patent holder, you have to pay a certain fixed dollar amount to another, and you have to repeat this process over tens of patent owners. Suddenly you're paying quite a large overall royalty, possibly 10% of the cost of a mobile phone, That's one figure which I've heard and Josue has agreed with. There is, to some extent, a partial solution to this problem, which is what is known as patent pools. Now, these are groups of companies who get together and effectively jointly license their patents. The idea being that you only have to negotiate with the patent pool rather than seek out each of the individual patent holders. The difficulty and problem with patent pools is simply that they don't cover all of the patents. So, for example, taking the big automotive patent pool, Avanci, they only have maybe 5 different companies contributing their 4G patents to it. You still are going to have to engage in a lot of other negotiations. Next slide. And it's inevitable that even if you're proactive, you're not going to be able to catch every single patent. So let's say you do get a letter, a licensing request from a patent owner. What do? Well, the most important thing is to engage with the patent owner. Seek legal advice. Don't just stick your head in the sand like the ostrich on this slide. You have to deal with it. The courts will expect you to negotiate with the patent owner in good faith, and there could be consequences if you just ignore it. Potentially quite a high award of damages against you, and possibly the award of an injunction to exclude you from the market. So now on to Simon, who will tell us a bit about the legal and contractual issues of negotiating a license.
Hello again. Well, I'm now going to talk a bit about touching upon some of the issues that we've already heard about, and also digging a bit deeper into some of the contractual issues. I think one of the interesting things about 5G is that whereas the previous Gs were really just telecoms, as we've heard, it's now bleeding out into other industries. So, and they often have their own technical and regulatory issues also. So, you know, we're now finding that there is scope for it to be used in greater connectivity in social care, sort of in cases of 5G nodes being installed on telegraph poles, and that so that you can then create a network to monitor social patients, keep them connected to their families, making sure that they're not getting dehydrated, that they're taking their medication and so forth. I've been recently involved with a client, his charity, in setting up an app for dementia sufferers so you can monitor them, and if in the worst case scenario someone suffering badly from dementia ends up wandering around and getting lost, then you can track where they are. We've also seen a development in agriculture of smart farming machinery, where you can have an automated system of irrigation and so forth, and integrated transport networks are coming, so that you have street lighting linked up, traffic control and autonomous vehicles. And also particularly important now during lockdown is the scope for remote surgery using VR. Now, as you can imagine, all these things, as well as being very technologically new and a quantum leap in terms of functionality, have a lot of regulatory issues and risks inherent in them, which you can add on to the intellectual property and commercial risks we've heard about so far. So next slide, please. And the other issue is that, because we've heard about all these SCPs, they're going to be combined in different forms. You might need some for your product, you might not need others. And as a result, it's going to be quite difficult to assess what would be a suitable royalty structure. For instance, you can see that in some cases, you might have a 5G element in terms of different domestic appliances being networked. And that is probably less crucial and less technically advanced than when you have a security and navigation system built into an integrated traffic network or an autonomous vehicle. So the latter would probably merit a bigger royalty than the former. And in some cases, the 5G element might be indispensable, and the integrated transport system is a good example of that. In other cases, it might be that it's not, it's just a better version of 4 or 3G, in that it's faster and higher definition, but not the raison d'etre of the technology. So again, you know, the royalty would need maybe to be calculated with that in mind. And then that's another layer of complication. Next slide, please. We've heard already from Philip about what patent pools are. And the idea is that because you have a whole load of patent owners grouped together, so you have a single conduit for your communications for potential license, that should make it simpler. And as a result, because it's more efficient, one would hope that the royalties will be lower. However, the trouble with patent pools is that you need enough licensors to buy into it to make it worthwhile and efficient, and often you always need one to take the first step. And also, if we end up with competing pools and you're working out which one you should be going for, and then it might end up having your door knocked on by another pool, it doesn't necessarily make it simpler. As we've heard from both the previous speakers, what is good is if you're proactive, you know, instead of just waiting for someone to say, well, hang on a minute, that's my patent, I would like a royalty. It's far better to go out there. And what some people are already talking about is it would be really good if licensors and licensees were talking to each other at the early developmental stage, because then you can work out what you need as your technology evolves. Now, on the one hand, that might mean that if the licensors are licensing out earlier, that they might be getting a lower royalty, but on the other hand, they might be talking to more potential licensees, so it might all be adding up. And of course, while the licensors do want to get their money's worth out of this, if royalties end up being too high, then you can see in the cases where 5G isn't indispensable, then the licensees are probably just going to stick with 3 or 4G. So all of this has to be borne in mind in the discussions to come. Next slide, please. So we've heard, you know, what you really need to do is speak to your patent attorney about the patent pools that you might need to talk to, and the license and the standards. We've heard that, you know, calculating royalties is complicated, and you're not always going to be ascertain what it's going to be. So set some money aside for royalties and for your legal and your patent attorney fees. And what I tend to say is calculate what you think you're likely to pay, and then add 50% on that, and you're probably going to be right. Remember also that you may not be the party directly interfacing with the licensor. You might be acquiring your technology from the licensee of the SCPs. Now, if that's the case, you're going to want the warranties from them against intellectual property infringement, that they're complying with the standards, along also with the standard warranties regarding the quality of the product they're supplying, and indemnities if they are in breach of those warranties, because you don't want to end up carrying the can. So it's, you know, in many respects, you're looking at the standard allocation of liability and risk management principles that you get in any contractual relationship. And they're all the more important now. The next slide, please. And then think again of, you know, what your liability is downstream to your customers and distributors and licensees. You know, you don't want to be giving any warranties unless you have the back-to-back warranties higher up. If your product, and you know, with it 5G in it, there is going to be an element of this. You don't want to be liable if there is any loss of connectivity beyond your control. So, you know, as I said earlier, if you're doing something like setting up a network to monitor patients or social care patients, or to carry out VR surgery, or a transport network so that autonomous vehicles don't crash into each other, or so that you can manage the traffic and the street lighting, you know, if there is less of loss of productivity, then it isn't your fault. You want to make sure that you are not liable in your contracts for that. So there is a case here of trying to allocate the liability between the licensor and the licensee and the user, and basically try and make sure that your liability is restricted to, you know, the areas that you can control. And that means having quite a careful discussion with your contractual partners. And then also making sure that, you know, you get insurance insofar as you are accepting liability. And talking to an insurance broker is, you know, not one of these things to undertake lightly. An insurance broker is very like a patent attorney and a lawyer. Different brokers specialize in different areas. So whether you operate in healthcare or medtech or electronics or telecoms or software or entertainment or charities or professional advice, different brokers specialize in these areas. And if you go to the right broker for your area, then you're going to get good risk management advice, and you're going to get put in touch with an underwriter that will give you better cover for better premiums. So don't just go for any old broker. And then the other thing is managing revenue. Make sure that if you're paying royalties onto a licensor, that in the same way, you have back-to-back credit terms with the people paying you. You don't want to end up being piggy in the middle where you've got to pay the royalties, but your credit terms with your customers or licensees or distributors are much more lax, and therefore you haven't got the money coming in to pay the money going out. I've known companies that have had a real problem there where they are dealing with big customers and they're paying with big licensors and big customers, and one is calling them for the money and the other isn't paying them. So make sure that in the same way with your liability, that your cash flow is equivalent to each stage of the supply chain. Next slide, please. A few sort of general points on once you've got your product, whether it be hardware incorporating 5G or software and content, how you know, you might be selling out there, you might be granting licenses to your technology so that others can do it. You might just be supplying, rather than supplying your software in a physical medium or download, you might be supplying a software as a service model whereby you're not actually giving the software to anybody. If you are supplying anything incorporating software, be very careful about incorporating open source elements. You know, these are very popular with code writers because, you know, they're cheap and often they're free and you have ready access to improvements. But remember that a lot of open source software comes with conditions on, and these may affect your downstream product. And you don't want to find that you're suffering from copyleft, and in the worst case scenario, the open source status of the software you're using has infected your own product, and that hamstrings your ability to commercialize it. If you're not selling directly in into the market, you might be supplying by a reseller, either of a sort of a physical product or of software, or you might be appointing an agent that can give you access to markets or territories that you're not familiar with, and then the agent gives you the customer and you pay that agent commission. So these are all options to bear in mind when you hit the market, and some of you may already be familiar with these models. I think one final point to make is that, you know, a lot of small companies are now going to be dealing if they aren't already, with big companies, both as licensors and our customers. And there are a few points you've got to be aware of here. And as we've heard earlier, the brand regime doesn't necessarily mean that you're automatically going to get a cheap royalty and then it's suddenly a level playing field. Remember that big companies also sometimes can't move quickly, and a small company needs to move quickly. You probably need a number of people in a big company to say yes, and they're rarely there all at the same time. So try and get your champion in the big company in negotiations, and also have an alternative lined up if your champion is no longer available. Also remember that sometimes big companies can use their standard form agreement, and it may not necessarily fit the scenario that you have. And also they will try and drive a hard bargain. But at the same time, if they want what you've got, then don't just assume you have to sign whatever contract they give you. I, a while ago, had a contract where I was dealing with a very small charity, and it was supplying audio and visual mobile phone content from one of the really big networks, and we had a bit of a fight in terms of making the contract do what we wanted. The other side wouldn't move in terms of IP indemnities regarding what our client was supplying, so we had to get some insurance in place, and luckily, because the client was a charity, the insurance broker managed to get quite a good deal. But just be aware that dealing with big companies is quite a different culture to dealing with small companies and research institutes. So you need to get your lawyer involved in a fairly early stage, even if it is just for some broad strategic input. Next slide. So I think we're now back to Philip.
Finally, how do you build your own 5G patent portfolio? Well, it's important to realize that trying to get standard essential patents is going to be a very expensive business. You have to pay to be a member of one of the standardization bodies. Typically, you have to attend their meetings. Obviously, that's a bit cheaper now in the world of coronavirus, but generally that would involve having to travel around the world at least once a quarter to attend these meetings. You have to apply for patents with no guarantee that your technology will even be incorporated into the standards. So it's an expensive process, but that doesn't necessarily mean that you can't obtain valuable patents. You can still obtain implementation patents, as they're called. These are patents for particularly good ways of implementing the standard. They're not necessarily the only way to implement the standards, but they're a good way. Or even you could get patents for particular use cases in which 5G could be used. Whichever you decide to do, it's important that you keep your invention secret until you have spoken to a patent attorney. If you go and disclose your invention, whether to the standardization body or to a potential company that you'd like to work with, that could ruin your ability to patent it. So before you tell people about your invention, go and speak to a patent attorney to get some advice on whether or not it's patentable. So that brings us to the end of clearing the 5G patent forest. I know we're running a little bit out over time, but I thought it'd be good to just have answer a couple of the questions that have come in. So first for Josue, the question is, why would building a patent portfolio or acquiring patents help when dealing with a licensor claiming to have thousands of 5G standard essential patents? We could never catch up. Could you answer that one for us, Josue?
Yeah, thank you, Philip. Yeah, I think the thing to remember is, as I mentioned, at the end of the day, a license discussion is a commercial negotiation. And so the more leverage you have, the better the outcome. And there can be typically what happens when it comes to a dispute is even if the licensor claims to have thousands of SEPs, if there is a dispute, typically there will be a handful of patents that are actually asserted in court. It's very rare there are more than 5 in any lawsuit, and that's because it becomes expensive. So in that context, arguably you don't need that many to be able to actually have a productive conversation and try to improve your outcome. I would also say it's not the only strategy we would recommend. As we've discussed before, understanding the economics of the case and other issues that you can bring to the discussion is important. But it's all about having leverage. And I would say don't assume it's minimal because you have only a few patents.
Okay, next question. This, I think it's one for Simon. Does 5G give rise to any privacy concerns?
Yeah, I think particularly because linked up networks and the exponential development of them that 5G is going to afford means that a lot of data, personal data on what people are doing is going to be linked up to other systems. So for example, one category of personal data is your movements. So you can see why monitoring someone's movements in an autonomous vehicle or having a joined up transport system results in that. Obviously also medical data is personal data, so any sort of networked form of healthcare, again, data that used to just be in a file or in a hospital surgery is suddenly out there. So as well as the normal licensing agreements, there are going to have to be detailed data transfer contracts and privacy policies built into agreements with users and with licensors and licensees. So this is a big challenge that everyone is aware of, but in the same way that the development of genetics proved a challenge for the patent regime and the development of digitization imposed a strain on the copyright regime, in the same way the rise of big data and of the greater connectivity that we're seeing is producing a real challenge to the privacy regime.
Thanks, Simon. So we have run a bit over time, so I think we should call it a day. So if you do have any more questions, then please feel free to reach out to the panelists today. You've got email addresses for Simon and me on screen. You can also get in touch with us on LinkedIn. So thank you for attending. Thank you to our panelists, Simon and Josue. It's been great to be telling you all about 5G patents. Enjoy the rest of the day. Thank you.